You know what? I'm going to actually just share the PDF. Does that look?
Yep, that's fine.
It sounds good.
All right, we are live.
Okay, let me begin then. First of all, welcome back to the Environment and Transportation Committee. I am, as always, your friendly chairman, Kumar Barve. This is really a briefing of the Land Use and Ethics Subcommittee. And so before I pass it over to Brooke, the policy of in my committee always is when a subcommittee has a briefing, the subcommittee chair takes control of the meeting. And so that's what's going to happen. You have before you the agenda for the meeting. So without any further ado, Brooke, take it away.
Great. Well, thank you so much. I appreciate that, Mr. Chairman, Mr. Vice Chair Stein. Thank you for joining us today. Good morning, everybody, and welcome to a briefing on ethics law in Maryland with the Environment and Transportation Committee and the Land Use and Ethics Subcommittee. A huge thank you to our presenters who are joining us today. A reminder to everybody to stay muted. And a huge thank you to Danny DePietro, my legislative director, who is our providing technical assistance today, to Patrick Tracy for his help, and to all our presenters. So we're 5 days out from a presidential election, so it seems like a great time to be talking about ethics in elected office. Because here in America and Maryland, accountability of public officials is very deeply ingrained within our constitutional framework and mindsets. The political and civic culture in our country is really based on the notion that public officials should always perform their duties in the public interest. I read a quote recently, the Government Ethics Office, the federal government wrote that, because it's even in the Constitution where we begin, we the people, and that those words really signify that all government authority, whether exercised by elected or appointed office, is ultimately derived from and accountable to the American people. So given this conception of public service, misconduct on the part of public officials presents one of the greatest threats to citizen confidence in government. And that's why we have an ethics subcommittee that looks at these laws. And it's why today we are going to get an overview of these laws and talk about what other states are doing and what we can and should be doing in Maryland as well. There's a good quote by the ethicist Dennis Thompson that any issue may be more important than ethics, but ethics is more important than any issue. And that's because, of course, ethics provides the preconditions for the making of good public policy. And so all policies depend on it. So without further ado, we're going to jump into our briefing today. We're going to start by hearing from Dia Daly, who is the Ethics Counsel to the Maryland General Assembly. Then we're going to move to hear from Jennifer Allgaier, who is our sort of newish Executive Director of the State Ethics Commission, and Kate Thompson, Staff Counsel to the State Ethics Commission. After that, we're going to turn to a national perspective and hear from Mark Quiner, who's the Director of the Center for Ethics in Government from the National Conference of State Legislatures. And we're going to end with some history and perspectives on Maryland's ethics laws from Professor John Willis from the University of Baltimore School of Public and International Affairs, who is also a former Maryland Secretary of State. So without further ado, Dia, great to see you. I'm going to turn it over to you. Thanks for joining us. And Danny, if you want to close the agenda so we can see Dia. Great. Thank you.
Okay, am I unmuted?
You're unmuted.
Good morning. Thank you for inviting me to join you today. It's nice to see all of your faces, even if you do kind of look like the Brady Bunch. Here's my plan for today. I'm going to give you a brief history of the public ethics law, how we got to where we are today. I want to talk to you about the various entities that are the players in public ethics in Maryland. And then I'm going to update you on what the Ethics Committee has been doing this interim. What's new since you adjourned sine die. As always, I'm happy to answer any questions you may have. So let's start with how we got here. Maryland, like many other states back in the 70s, was very interested in public corruption. So the General Assembly created a special joint committee on ethics and conflicts of interest. That group met and that their work ultimately culminated in the modern public ethics law. Kind of riffing on what Delegate Learman said, when the General Assembly adopted the ethics law, you said that our system of representative government is dependent on the citizens of the state, the public, being confident that people, officials, employees weren't subject to improper influence or even the appearance of improper influence. To get to that point, you established certain conduct rules to avoid conflicts of interest. You required certain officials and employees to disclose information about their financial affairs so the public could see what was going on and to know that we were acting in the public's interest, not our own interests. The first major revision of the ethics law came in the late 90s, early 2000s. We had a 4-year period where we were really busy with ethics work. In 1998, the General Assembly created the Special Study Commission on the Maryland Public Ethics Law. That group met, it was chaired by now Senator Ben Cardin. The committee met over a year, did a whole lot of work. Their work resulted in a public ethics law, revisions to the ethics law in 1999. And you made substantial revisions that year. While there were certainly many provisions that impacted all of state government, I would say that the 99 legislation primarily focused on the General Assembly. You completely rewrote the process that the Ethics Committee would use in administering the public ethics law. You clarified the rules related to conflicts of interest for legislators. That was when you first adopted the general prohibition against legislators receiving earned income from state or local government entities. You substantially restricted legislators being compensated to represent people before state or local government entities. You tightened up the gift rules. And probably my favorite part of the 99 ethics legislation, you created the position of ethics counsel. There was a feeling in the General Assembly that you didn't have someone you could go to get confidential advice. You wanted a subject matter expert that you could speak to about your specific situation because you wanted to make sure you guys were doing the right thing. Sometimes the rules can be confusing. So thank you for creating that position. My family appreciates it. So the following year, in 2000, you created a study commission on lobbyist ethics. That group did its work. The General Assembly acted on those recommendations in 2001. And there we saw substantial revisions to the lobbying law. You gave the Ethics Commission some additional sanction authority, some additional options for sanctions. You expanded the registration triggers so that now certain advocacy before an executive branch agency can require someone to register as a lobbyist. You increased reporting requirements, and then you adopted a series of prohibited activities for lobbyists. For example, lobbyists can't counsel someone to introduce a bill for the purpose of opposing it. A lobbyist can't counsel someone to violate the ethics law. You substantially restricted what lobbyists can do with respect to campaign fundraising. So then moving on, the next and most recent change to the ethics law came just a few years ago in 2017. So in 2017, you revised the law in a number of ways. You expanded the definition of legislative action to make it clear that if you are advocating as a delegate before a state or local government entity, that is legislative action. And the same conflict of interest rules that apply to whether you can vote on a bill also are going to apply if you can testify before a local government agency as a delegate. There were a number of other changes that went beyond the General Assembly. For example, you established a cooling off period, a 1-year hard and fast cooling off period for the governor, the lieutenant governor, the comptroller, the Attorney General and the Treasurer. You established a reverse cooling off period. So if a lobbyist had been lobbying on a specific matter, they had to wait a year before they could come to state government and work on that same matter. There were additional restrictions that I would call primarily clarifying. You expressly stated that an official or employee can't steer a contract to a specific person or entity unless it's part of their state job. You expressly stated that officials and employees can't use public resources to solicit campaign contributions, that employees such as cabinet secretaries can't use their titles in campaign fundraising activities. So those were the three major periods where we had changes to the ethics law. You've had little tweaks at other times, but if we're looking at big ethics changes, we've got those three periods. One of the areas where I do see a lot of confusion, I think quite often legislators, state employees, the public don't understand who does what as far as regulating public ethics. So I wanted to try to clarify that for you. You guys are all familiar with the Joint Committee on Legislative Ethics. The Ethics Committee has jurisdiction over legislators. They do not have jurisdiction, however, over your staff. Your staff is under the Ethics Commission's jurisdiction. If we're talking about a judge or a judicial appointee, they're subject to the jurisdiction of the Judicial Disabilities Commission, the Judicial Ethics Committee, or another entity designated by the Court of Appeals. And then the Ethics Commission has everybody else. So they have a whole lot more jurisdiction than the other two entities do. They have jurisdiction over all state elected officials other than legislators or judges. So you hear that and you think about the governor, the lieutenant governor, the attorney general, and the comptroller. The people you often don't think of as being state elected officials are the elected state's attorney, the elected sheriff, the elected register of wills, the elected clerk of the court in each county. Those are state elected officials, and the Ethics Commission regulates them. The Ethics Commission has jurisdiction over employees in all three branches of government. One group we often forget, you create various state boards and commissions. Some of them are determined to be executive units. That means that the members of those commissions, even though they may not be paid, are subject to the public ethics law. So let's use the Ethics Commission, for example. The members of the Ethics Commission are not compensated for their service, but they are subject to the ethics law. So sometimes we forget about those people. And then finally, the Ethics Commission regulates lobbyists. I want to give you a brief update on what's new in ethics world, what we didn't get a chance to talk about last session, what's changed. As you probably are aware, early last year, the presiding officers authorized legislators to use a program that our IT department is providing that allows you to send periodic electronic legislative newsletters to constituents. The newsletters I'm talking about are your official newsletters. They're coming from your General Assembly email. They're being sent using this program we have. I'm not talking about your campaign newsletters. We're just talking about the newsletters you're sending through our system, the ones that are coming from the General Assembly email. So we roll out this new system to send newsletters. And as you can imagine, there were a whole lot of questions. So people wanted to know, what can I put in my newsletter? How can I get email addresses of recipients? So the Ethics Committee has been working on that this interim. In fact, you all received an email from me earlier this year, actually probably 2 or 3 weeks ago, that included a couple documents that are going to give you some guidance on your legislative newsletters. You should have gotten a frequently asked questions on electronic newsletters, as well as a revised ethics opinion 12 that has been expanded to include those newsletters. If you didn't get it, if you need another copy, just call me and I'd be happy to send it to you. But here's the general rule. As a general rule, when you're trying to figure out what you can talk about in your newsletter, unless we specifically say otherwise, the same rules that apply to your General Assembly email, that apply to your official correspondence, your official letterhead, are going to apply to your legislative newsletters. There are a couple areas, there are more than a couple, there are a few areas where we've carved out a special rule, and those are going to be spelled out in that revised Ethics Opinion 12, in those frequently asked questions. And then if you review your ethics guide, there is a discussion with guidelines for the use of the General Assembly print shop, mailroom, email, and it now includes newsletters. We've carved out some special rules for newsletters there, so I would encourage you to take a look at it. I'd like to highlight a couple things. The big question that we got about newsletters was linking to social media accounts. The General Assembly addressed that through legislation last year. So there was a bill that dealt with electronic newsletters. One of the provisions of the bill said that you may, in your electronic newsletter, link to your social media account if and only if you're using that account to communicate legislative and constituent information. You are not using the account primarily for electoral purposes, and you are not using the account for your own personal gain or the personal gain of another, except for a usual and customary constituent service. The Ethics Committee talked about that a little bit in that revised Ethics Opinion 12. One of the things that came up in our discussions is what happens in the days leading up to an election. There are different concerns when we're in the middle of the year versus a week out from an election. So here's what the Ethics Committee said. For a state election, a state primary or general, regardless of if you are a candidate or not, in the 60 days leading up to that election, your official legislative newsletter may not include a link to your social media account. For a federal election or a local election, primary, general, or special, if you are a candidate, your newsletter can't include a link to your social media account for 60 days. So we have a 60-day blackout period before elections. If you have questions, call me on that. I'm happy to talk to you about it. Another thing that came up, and this is unique to social media, we were getting lots of questions about blocking, hiding, deleting comments, preventing people from participating in your social media accounts. The Ethics Committee has opined that if you are using state resources to create, update, maintain, or link to your social media account, you may not block, hide, delete a comment, a person, simply because you disagree with the viewpoint. I want you to be aware, however, that the First Amendment may place some restrictions on a social media account, even if you're not using our resources to maintain that account. So I want you to be aware we've got two issues. We have the ethics rules, which are very much linked to us, but there are also First Amendment issues that you should be aware of. That's pretty much all I have for you. I am happy to answer any questions, and thanks for inviting me.
Thank you. Appreciate that. Great update, very informative. We're going to turn it over to Jennifer and then Kate for an update and introduction from them. I don't think Jennifer's had the chance to brief us in her new role. So welcome, great to see you, and thanks for joining us today.
Thank you. Hi, everyone. Thank you for inviting Kate and I to participate in this briefing today. I'm Jennifer Alger. I'm now the executive director for the State Ethics Commission. Usually Mike Lord would appear before you. Mike retired in June. And so we had some shifting around in our office. And I was previously the general counsel. I've been with the commission this summer will be 20 years. So I've been around a while there in the office. But now I'm serving as the executive director. And Kate Thompson, who is in the row below me there, she was the assistant general counsel working with me for 7 years or so. And now she is our staff counsel. But Kate has graciously agreed to continue helping me with the legislative end of everything for the commission this year. So she's a familiar face to you, and she will be back at it again this session. So thanks for having us. What I would like to brief you all on today is more about the State Ethics Commission itself, the commission's functions. Dia covered the State Ethics Commission's jurisdiction, so I don't want to use the time to repeat everything. She covered everything. She used to work with us too, so she's a good one to hit all of those highlights. And I also wanted to highlight some differences that are in the provisions of the public ethics law where something may apply to you all as members of the General Assembly differently than the restriction applies to a state employee or an executive branch official or a board or commission member. So I just want to kind of hit those highlights. So if there's some confusion on why you all may or may not be able to do something that somebody else can do, that's what's going on there. Just to cover a little bit about the actual State Ethics Commission, it's similar to your Joint Committee on Legislative Ethics. Our State Ethics Commission is a 5-member commission. They are members that are appointed by the governor, but 1 member is the nominee of the President of the Senate. 1 nominee is a nominee of the Speaker of the House. 3 are nominees of the governor's office, but 1 of those gubernatorial nominees must be of the opposite political party of the sitting governor. They serve 5-year terms. Their terms are staggered, so it's not a situation where there's a giant turnover at one time. And it's an independent body. The State Ethics Commission staff, the members of the commission, we're an independent agency and we take that independence seriously. And the commission meets about 7 times a year. We're located in Annapolis. Our office has 12 full-time employees. Right now we're scattered, as all of you are as well. But that, it's a fairly small operation, but as you'll hear in the next couple minutes, there are many programs and things that the State Ethics Commission is responsible for administering under the public ethics law. One of the main functions of the State Ethics Commission and its staff is to provide advice to state employees, state officials, members of state boards and commissions, lobbyists, local governments on the provisions of the public ethics law. We give a tremendous amount of advice all year, especially to state employees on conflict of interest provisions, mainly on secondary employment. So there is a lot of advice. We have both formal advisory opinions and informal advice. So we do that all year long. We also have an enforcement division that enforces compliance with the provisions of the public ethics law, and that covers conflict of interest, that covers financial disclosure, and that also covers the lobbying provisions as well. We administer the financial disclosure program for everyone in the state. So I'm sure that you all may be familiar with our office in that capacity with your annual financial disclosure statement. So our staff works hard to help people set up their accounts, go through if they're troubleshooting, they're having an issue, actually help you file your account. If you have a question about what needs to be disclosed, we deal with that. We have staff members that for a time period are pretty much dedicated to username and password changing or generation. We audit financial disclosure forms. That's one thing that many of you as members of the General Assembly, our staff does review the elected officials' financial disclosure statements. We try to, if there's something missing or something that needs to be highlighted, it wouldn't be unusual for you to receive an email through our financial disclosure system, just asking for additional information or if something is missing there. We also administer the state's lobbying program under the public ethics law, and that would be the lobbying registration, lobbying reporting program. We have an element of training for lobbyists. And again, that also ties in with enforcement and providing advice as well. Our office houses a lot of public records. Your financial disclosure forms are public records, lobbying records are public records. So we do have that element of disclosure and availability to the public also. I did mention training for lobbyists. Our commission also does training for state employees. Any state employee that's required to file an annual financial disclosure statement also has to take a one-time 2-hour financial disclosure financial disclosure and conflict of interest training. We have that available electronically on our website. That's been in the last several years that we've gone to the training online, but we also do from time to time present in-person lobbying training, both for employees and for lobbyists. The State Ethics Commission is involved in local governments, in that local governments, counties, Baltimore City, many municipalities, all the local boards of education have to have their own ethics laws or ordinances or policies that meet the standards that the General Assembly sets for them. And the State Ethics Commission's role in that is to review all of those changes, to provide advice and guidance, and to actually, when they're ready, approve the local ethics laws and ordinances and policies to ensure that they have met all of the requirements that you've set for those local governments. So that's a large portion that's kind of covered in our advice department as well. I think we provide, we have our website and we provide some general information for the public as well, memos, information, lobbying lists, access to lobbying records that's on our website. So that is generally what we do there. The next thing I did wanted to touch on was highlighting some of the provisions in the public ethics law that may be different for state employees than members of the General Assembly or for executive branch officials. One is participation. The participation restriction is that it prohibits state official or employee from participating in a state matter where the employee or the official or a qualifying relative of the employee or official has an interest. Your qualifying relatives for this purpose are going to be a parent, a child, a spouse, or a sibling. And then that prohibition extends to matters where a business entity is a party to a matter if that business entity has certain relationships with the official or employee or their qualifying relative. For example, it's an employer, it's your spouse's employer, or it's the company that your sister owns, or it's a company that your father is, has a debtor-creditor relationship with, something of that matter. Then the law says you can't participate as a state employee or official in matters where those entities have an interest. But then, what's an interest? The interest has to be some kind of a legal, equitable, or economic interest that's owned or held wholly or jointly by the official or the employee, either directly or indirectly. Covers your qualifying relatives holdings as well. And so we look as an interest, can be any of those things. But also it's got to be an interest in a matter. And the commission tries to be a little bit more specific when we're talking about a matter. Matters aren't general policy matters, they're more specific. It could be a particular application. It could be a particular contract that that the state has. It could be a review. If we're talking about one of our state board or commission members, it could be a licensing issue or an enforcement matter that comes up before a board or commission. If there is that relationship where the actual official or employee or their qualifying relative has some nexus or relationship to either the business entity involved or they actually have that interest themselves, then the non-participation restriction would kick in and say, you can't participate in that matter. And by participating, the State Ethics Commission has given really broad advice. Participating is really anything. It is being involved in the discussion. It's being involved in voting or reviewing a matter or making notes or suggestions on something, or even supervising other employees. Because if you as a supervisor can't participate in the matter, then it makes sense that you can't supervise the people that are participating in that matter. Of course, they're going to want to make their supervisor or their boss happy. So in order to remove that potential influence, the ethics law says, okay, you're out, employee with the conflict. Someone else has to be designated to supervise those employees or oversee their participation in that particular matter. Some examples that we always use with that is, if you're a state employee that's on a review committee and to award a contract, state contract, and as you are opening up the bids and starting your review, you see a bid that has come in from the company that your sister works for. That ends your participation in that particular matter. And something that's different on with this provision, different than what you may have as members of the General Assembly, is it doesn't allow for just disclosure, make it be known that I have this conflict and then go ahead and participate. The restriction is you can't participate at all. There are some limited exceptions that would allow you to participate if that conflict exists. One is to actually get an exception from the State Ethics Commission. The commission reviews the regulatory criteria that are established, where they're really kind of parsing all of the specific facts to see, does an actual conflict of interest exist here? An example where the commission has granted a participation exception has been a state employee who had an adult child that worked for an engineering firm in a Seattle office. And that engineering firm also happened to have an office in Baltimore. And the Baltimore office was the one that had a contract with the employing agency of that state official. The participation law on its face would say you can't participate in that because ABC company employs your son or your daughter, and they have the contract with your agency, you're out. But the exception criteria would allow the commission to look at factors like, will this qualifying relative have duties related to this contract? Do the qualifying relative and the state employee have joint financial interests or joint debts in any way? Would they be working together in that? Would the state employee or official have duties that could really affect their qualifying relative in this matter? And if the commission can go through all of that and make the determination that really the conflict of interest doesn't exist, then it allows them to grant an exception and the state employee could participate. Those are kind of few and far between. There are strict regulatory criteria that have to be met there. And also the agencies involved they have to approve of that. They have to support the exception request. And then they have to outline any ways that they could act to try to contain any appearances of a conflict of interest. Yes, the employee might be able to participate, but they're not able to approve invoices or other restrictions that they could do to minimize any appearance of a conflict of interest. So that's a difference there with participation. Another thing that is different for members, state employees or executive branch that is different than the members of the General Assembly is you all aren't subject to the section in the public ethics law that deals with restrictions on outside employment and financial interest, but other state employees are. And I can tell you that a large amount of the advice requests that our office get every year are from state employees that are seeking to have their secondary employment reviewed. The secondary employment and financial interest restriction starts with a strict prohibition that says state employees and officials shouldn't have outside employment or financial interest in any entity that has a business, contractual, or authority relationship with their particular governmental unit. And then there's also a restriction that says you can't have outside employment that could impair your impartiality or independence of judgment in your state position. And all of these secondary employment requests are really reviewed on a case-by-case basis. With the strict prohibition, there's another situation where the commission has regulatory criteria that would allow the State Ethics Commission to grant an exception to allow a state employee to have that outside employment, but they still have those participation restrictions and prestige of office restrictions that kind of serve as a safety net to prevent actual conflicts of interest in those situations. An example of that, we get a lot of state employees that will work for the local Department of Social Services. And then they may be in one unit of the local Department of Social Services, but they also have an outside job where they do weekend caregiver work or something else. And the outside employer may receive money from the Department of Human Resources, or there may be a referral relationship from a different division of the local DSS office. And on its face, that would be prohibited. But when the State Ethics Commission reviews all of the information and reviews that against the exception criteria, they may be able to allow that employee of the DSS to have that outside employment. We want to make sure that they don't have specific duties in one position that relates to the other, those types of things. But there are circumstances, and we see a lot of them, where those types of employment situations can be approved. Another provision that we have some differences for members of the legislative branch, members of the executive branch, and state employees is gift exceptions. You get advice from DIA, and we love to refer our calls to DIA if someone calls us and says, we're thinking about inviting, Delegate Barve to this. And then the answer is, well, call DIA and make sure that DIA says that's okay, and then call us back and we'll tell you how to report it. But the gift provisions really are different. For example, one thing that you all can do that the rest of us cannot do is you may accept tickets to political, cultural, or charitable events. So, as a member of the General Assembly, you may be invited to a gala that celebrates a particular charity that maybe you've been involved in or is housed in your district. You can accept those tickets to that particular event, but your staff members can't. State employees can't. So if, they also reached out to Kate and I and said, would you like to come to this gala? Well, we would love to, but we would have to buy a ticket. We couldn't accept that free admission. So that's something that's different and something to keep in mind too, to make sure that, you're kind of keeping on, know what your staff would be doing. If they have a question about that, knowing that just because something's okay for you to accept doesn't mean that those same rules apply to members of your staff as employees of the state. So that is one.
We have a couple of questions. Would you mind if we jump to some of those? I just want to keep moving and make sure we don't run out of time for some of the questions. Is that okay? Are you almost through? Okay. So Delegate Boyce, you want to start us off?
Hello.
Hi, good morning. Good to see everybody. Dia. So one of the reasons why I do not use that electronic newsletter system is because I don't understand it and I just don't want to get myself in trouble. So I just don't use it. I'm just putting that point out there. I just don't use it. So I have a question about blocking people. And And so, as you may or may not know, whether it's a Facebook or Twitter or well, more Twitter and Facebook, it can get really toxic. And so I guess the question is when it is toxic, when it is very nasty name calling or vulgar words or racially motivated. So when is it okay to block, or is it always advised to check in and then get the advice about whether or not to block somebody? Because blocking, in my observation, usually comes because of an individual's inappropriate behavior on social media that is toxic and stressful, and not necessarily because, you know, somebody wants to send you a message every 5 minutes and just kind of overwhelm your system or nag you.
So a couple things. You should have a policy for your social media accounts that says, look, we are not going to allow threats. We're not going to allow profanity. So you want to put that out there up front. As far as, it's a tricky line as to when someone is crossing the line into being just abusive, threatening, versus they just won't stop saying, you know, the same thing again and again. I would say reach out to me, reach out to the AG's office. I am going to, when we get off this call, I'm going to send you a document that the AG's office put together that kind of talks about what the court cases have been, because I think that's a lot of, I think that's going to address your issue. You know, you're not using our stuff for your social media accounts. This is your personal social media account that you're updating using your phone and that type of thing. That becomes more of a First Amendment issue than an ethics issue. The AG's office has done a lot of research on that as far as when the courts have determined this isn't your personal account, this really is a public forum. But I will send that to you as soon as we get off this call, okay?
Thank you.
Okay.
That's helpful. Delegate Love.
Thank you, Madam Chair. Dia, will you send that to all of us?
Yeah.
I was going to say, just send it to our chief of staff, Trish, and she'll distribute.
I will send that to Trish as soon as we get off the phone.
Okay, great.
I had a question about funding. How much do we fund the ethics committee, and is it, or commission, and is it adequately funded?
Well, I would say that we could always use more funding here. We are a pretty low budget operation. I think that our operating budget is just over $1 million a year, I think, 1.2. I don't have that number in front of me. I can send that to you, Delegate Love, but I know that the majority of our spending is for our staff salaries. And beyond that, we really don't have a lot of funding. So any extra funding would be fantastic. It helps us to expand training, outreach, update systems. That's one thing that we have been doing in the last few years. We did get some funding to update our electronic filing system for financial disclosure and for lobbying, and then to also update our training, electronic training. So that's really where the commission has been spending its money lately on that. But as I'm sure all of you are aware, many of the state agencies had to give back some funding. In this fiscal year, the State Ethics Commission was asked to return $60,000, which would have been money that was earmarked for updates and things of that nature in fiscal year 20. We did that maybe in March, April, May at that time. So I guess the short answer to your question is I don't know the exact budget. I wish I did. I'm sorry, I was not prepared for giving that number today, but I can get that information and send that to you. But more funding is always welcome in a small agency.
Thank you.
Thank you.
Thank
Thanks
you. Thank you for that. Got to make sure you have the resources you need to do this work. So thank you. Delegate Terrasa had a follow-up question to Delegate Boyce's question.
Well, first of all, I'd like to echo Delegate Boyce's statement about it being confusing, the whole newsletter thing being confusing, but it seemed like your answer was more focused on the fact that Delegate Boyce does not she doesn't use the public system to send out our newsletter. So if you do use the public system to send out your newsletter and you do link your social media account, I'm wondering, you talked about the First Amendment having other reasons to not block somebody, but are there reasons that you would block somebody? And what I worry more about, I'm not worried about somebody being abusive to me and saying nasty things to me. I'm kind of
We're over it.
yeah, I'm over it. That doesn't really affect me. What I worry more is about racist or nasty comments to another constituent of mine on there, or basically abusive or threatening comments to somebody else, and my ability to block those. So sometimes it has a chilling effect on my decision to post something, because I worry that somebody will be nasty to somebody else and not to me. And do we have the ability to shut that down in any way? Or we're just stuck at that point?
So I would say that's where it's going to be really important that you have a good policy upfront on your social media. So you're going to say, we do not tolerate not just threats, attacks of you, but we don't tolerate one person threatening another person. We don't tolerate profanity. We don't tolerate, I'm trying to think about other examples. But here's what I'll tell you. A lot of it is going to be very fact specific. So I am happy if you have a policy and you want me to take a look at it, I'm happy to take a look at it. And also if something comes up and you say, hey, this is just terrible what's going on, can I block this? Please reach out to me. It's hard to, draw a firm line of this is okay, this isn't okay. It is going to be very fact specific. So like I said, reach out to me.
Okay, and can I just follow up really quickly on that? And where would we put that policy?
I think you can put it in the about section,
Okay.
like the same place where if it was your campaign, where you put your authority line.
Okay.
I think in there you
So
can
that's what you recommend.
put information there.
Okay. Thank you.
Mhm.
That's helpful. I think if there's standard language that could be shared with members, that might be helpful. Delegate Holmes asks if, in addition to the AG's information, you could also please send to Trish ethics opinion number 12, the updated version. And Delegate Clark has a question.
Thank you very much, Madam Chair. And I don't want to get into a deep conversation about this now, but I remember, I think it was last year or year before, on some, I believe it was a conversation about ethics bills, that there was some proposals about the Ethics Commission having the ability to fine people that violated ethics rules and things like that. And I was wondering if we could maybe have another conversation about that and just what the Ethics Commission should be able to do and not do as far as being able to fine people for violating the Ethics Commission and our ethics rules, and also if they do something that's illegal, obviously it's a violation of ethics, whether they have the ability to fine people. I'd just like to listen to the pros and cons at some point in time from the Ethics Commission as to whether that's a good thing or a bad thing. That's all I had.
Thank you. Does anybody want to respond? If not, that's okay. Okay. Let's see. Any other questions here? I had one final question for you all. I guess I'm surprised about the number of secondary employment requests that you seem to be getting. And I'm curious if you mentioned DSS workers, who of course are some of our lowest paid state employees. And I wondered if you had ever done, or if there's sort of data on how many secondary employment requests you've gotten over, say, the past 15 to 20 years, and like broken down by department and pay grade. I mean, my guess would be that our lower paid employees are seeking secondary employment more often. And I'm just, to me, that indicates a failure of state government to pay people for what their jobs are worth and what they're doing. And so I would be curious to see if you've done any sort of analysis, or if you've thought about it, or what your thoughts are.
Thank you for that question. We actually do include information related to the number of secondary employment requests that the commission gets every year in our annual report.
Okay.
And so those annual reports are available on our website, ethics.maryland.gov. And I believe that we still do break down some of the advice requests by agency. I think last year, total informal advice requests that includes all, secondary employment, conflict of interest, participation issues, those kinds of things. I think we were close to about 700 advice requests that came through our office.
Wow.
And probably, and Kate, jump in if I'm steering down the road on this one, but I would say probably of those 700, probably closer to 450, maybe up to 500 of those are secondary employment requests. And we do see a lot of secondary employment requests that come out of employees of the local departments of social services, the local departments of health, a lot of those, social workers, counselors, folks that are in that. We see a lot of that, but we also, we see a bit of it from all agencies, but I think that we do see a very increased number that come disproportionately, I think, from the local DSSs and health departments.
That is really interesting. I mean, it might be worth a separate report at some point on advice opinions like that, just to dig in a little bit on what is actually happening with our employees that they need to request information. I wonder if that's even something DLS should look at. 500 employees asking to work outside of their full-time jobs seems like a lot.
With those, it depends really. Like some of the agencies, their policy is if their employees are doing absolutely anything outside of their state job, they'd like to have it reviewed. And that could include things like they're selling Pampered Chef, right, or, they have, some side, business, anything like that. So
right.
Sometimes the numbers that are reported really also reflect agencies that are more on top of having all of their employees report those things. I am sure that there are more secondary employment, state employees with secondary employment out there than are reflected in the advice requests that we get as well.
Right. And I appreciate that. I think it's really, and this is not to in any way place blame on employees who are seeking secondary employment. My concern is solely that there are so many people who need an outside job because perhaps their salary is inadequate. So, but thank you. And let's see, any other questions before we move on? I don't think I saw anybody else. And I realized that I wasn't sure if Kate was here to present or to answer questions, but if she'd like to speak for a couple minutes, we'd be happy to hear from her.
Great, thank you.
Sure.
It's good to see everybody again that I've met. I just have a couple of quick things legislation based as we get into the session. Because Jen and I will be your primary points of contact. If you all do not know, we are happy to be a resource for information on bills that other people submit and that you have questions about how they might actually be enacted and be working with what we already are doing. And also for bills that you think you have a really great idea about, we want to, with love, if you're comfortable hearing a little bit about it in advance. So we're not trying to play catch up once they hit the floor, which would be really great. And we are happy, like I said, to be a resource. We often put in informational testimony. Do not be alarmed by that. Our commission likes to just sort of let people know what our thoughts are on it and how it will fit in. We almost never take positions if they're not departmentals. So we will often do informational testimony. We will always provide that to you all in advance of it hitting. So just so you know, and we'll be expecting it. The last thing is, just briefly, you all have Dia, who is such a good resource, but we are also available if you have any questions about your financial disclosure statements, you need help filing them. We are a great resource. Like I said, we have a bot that audits, but we also personally audit all our electeds. So if you get an email, it's probably going to be from me saying, I noticed that last year you said you had Apple stock and this year it's not there. Why is that happening? So we're not scary. It's just me. So just call me back or email me and we'll figure it out. And then the last note, which I'm sure Dia will remind you of too, but substantial change forms are coming up, being due in January. If you have any questions with any of that, reach out to our office. We're not there, but we are, we're on the VoIP system now. So all your voicemails will go directly to our inboxes, which is great. And we will get back to you. So that's all I had. I just wanted to let people know if they didn't, sort of how our legislative process works in our office as we move through.
And
that's excellent. That's very helpful. Thank you. Sorry, go ahead, Jennifer.
Our contact information is included in the ethics law summary that that we sent in. So I think all of you got a copy of that, but our emails are there. So as Kate said, we are still, a lot of us are working at least part-time remotely. Sometimes we're in the office, but email is a good way to get us. And then Delegate Love, I did get information back on our budget. So I do have that information for you. Our budget was $1,370,837. And that was after we were asked to give back $60,937 this year. So that's where we are.
And just, can you tell us again how many staff are in your office who are like reviewing requests for opinions?
We have 12 full-time staff. That staff is the executive director, the general counsel, the assistant general counsel, the staff counsel. So we've got 4 lawyers, and then we have our office manager, Darlene Brocky, who some of you may deal with. We have someone that is in charge of our boards and commissions. She's also doubles as our receptionist. We have a financial disclosure compliance officer that goes through and tries to make sure everybody's filing their forms. We have a lobbying coordinator, a financial disclosure coordinator. We have a legal assistant assigned to general counsel and assistant general counsel. And then we have 2 paralegals that assist the staff counsel with our enforcement matters. I think that's everybody.
Thank you. I apologize to my colleagues. This is my old appropriator side coming out, wondering about the ins and outs of the state agency. But I'm just amazed that your tiny office does 700 opinions every year in addition to all your other duties. Wow. So thank you. Thank you, Kate. Thank you, Dia. Thank you, Jennifer. We really appreciate you being here today and sharing all of this information. And anything you want to forward to Trish, we'll make sure she's awesome and she'll get it out to all of us as a follow-up as well. So thank you. Now we're going to turn it over to Mark Quiner, who I'm very excited to hear from the National Conference of State Legislatures. He's going to talk, I don't know, between around 8 minutes, just give us a little overview of what's happening on a national level in ethics laws and the resources that NCSL has to offer. So Mark, thank you for joining us today.
Yes, thank you. Thank you. It sure is nice to be with you. I wish I was in beautiful Annapolis. And by the way, that's one capital. I'm a little embarrassed to say this, but that's one of the few capitals I haven't been to. So please let me come there when all this craziness is over. But anyway, thank you. A little bit about me. I worked for the Wyoming legislature for about 26 years and served as the director of the Legislative Service Office, which was the nonpartisan agency. And, you know, Wyoming's small, so we were the only staff they had. There was only like 35 of us. So anyway, I know what you guys are going through on a smaller scale anyway, or Wyoming. But anyway, it's nice to be here. I'm the Ethics Center has been around since 1999. And so we're kind of proud, we at NCSL are kind of proud that we have a center like this. And so thank you for letting me present. Just for the highlights, I was asked, and by the way, thank you, Patrick and Danny, for helping put all this together. But I was kind of asked to talk about trends and what's going on sort of from a national perspective. And what I can tell you is I'm not in all 50 states, but we do track all 50 states. And I just thought it was interesting that our website now, that just the ethics stuff, gets over 300,000 inquiries a year. And I get a lot of calls and questions from legislators, staff, and lobbyists and members of the press. And the number one questions that I find that I'm getting, first of all, and by the way, the most, not the questions, but the most viewed web pages I think is interesting. The number one web page is our 50 state chart of criminal penalties for public corruption. So I guess we start with the scared end of it all. And then we move to some of the finer points like what are lobby definitions? What are nepotism issues and prohibitions? What about lobbyist registration? And then conflict of interest. I would tell you from your colleagues as legislators and even legislative staff, I think the number one questions I generally get are gifts. What is appropriate? What can I do? What can I, where can I go? What can I receive? And I'm glad you had on your local expert or state experts previously. I really enjoyed their talk. When I go into a state, I really like to have them literally by my side, because when the specifics come up, I'm really not generally well-versed enough in the state laws, other than Wyoming's, to talk about what you can and cannot do. So I'm really glad about that. So, but the number one questions I generally get from your colleagues and staff are really about gifts and then conflict of interest. And oftentimes, as you know, a gift can lead to a conflict of interest, but we also track financial disclosure, and I know you all are allowed to file yours electronically, etc. Lobbying is kind of an interesting topic right now because, so we're doing this, right? Well, what does contact with a legislator mean? In some states, it's very well defined. And I just looked at Texas because they're wrestling with this whole, is Zooming lobbying, et cetera. And, their law says telephone, telegraph. Anybody? When was the last time you ever got lobbied through telegraph? I'd like to know. We'll put a story out on you. That'll be interesting, right? Telephone, telegraph, or written letters. Well, let's all be honest now. There's not a lot of written letters going on anymore. Most of it's electronic. Some of you were talking about your website, etc. So I think some of the issues are going to be what constitutes contact with a legislator that meets the definition of lobbying. The other thing I think we're noticing is honoraria, which, believe it or not, legislators, certainly former presidents, get big honoraria for speaking. and issues related to that. I will tell you that around half the states allow a legislator to receive honorariums. I don't know whatever plural is, honoraria for their talks, but the other half don't care. Wyoming doesn't care. You can go talk and get money. Yeah, God bless you. So here's the other thing that, and I thought your recent law that Patrick shared with me, House Bill 1404 on the financial disclosure stuff and the blind trust, I thought that was interesting. That actually is becoming a trend right now, blind trust. And you know what, just a personal aside, I have one of my very best friends is now a member of the presidential administration and had to put one of his businesses in a blind trust, and I had to be the trustee. So I learned, certainly on a federal level, what it was like to, and I'm like, you want me to do what? Anyway, the blind trust stuff, digitization, I hope I'm saying that right, is a relatively recent phenomena. Digitized disclosure documents, lobbying registrations, financial reporting, financial interest reporting, all that, especially now that we can't, walk around in person. And then like I said, the honoraria is the sort of the conflict of interest provisions. And then we're also seeing quite a bit, and I don't know if there's a lot of bills being filed or who's pushing this, but a lot of interest seems to be in the nonpartisan staff. What can they do in the political arena and what can they not do in terms of, can they donate? Can they participate, et cetera? So that's kind of interesting. The other thing that I wanted to add was that open meetings laws, when the open meetings laws were written, generally they weren't anticipating this happening. Oh my gosh, we've had some that if two or three, you remember the old verse in the Bible about where two or more are gathered? Well, some of those laws really say two or more even in a hallway, that's a public meeting subject to the Open Meetings Act. So that's been kind of crazy. And so when this first broke out, a lot of legislatures, and they still are, by the way, I was doing one late last night for a West Coast state, saying, what can we do? I mean, what's happening? How are legislators meeting, et cetera? So the pandemic is requiring a lot more, I would say, creativity. And then, like I said, what's the definition of a lobbyist, et cetera? And shameless plug, we track all 50 states, including yours, on our website, ncsl.org. And as members, you can go on and create your own personal login and ID and have all the information. Yeah. Oh, thank you.
Sure.
You just put that in chat. Excellent. Thank you. That was very helpful. Anyway, so you have access to everything, and you can always call me in the Ethics Center, and happy to talk to you all or answer any questions. I have lots to say, but given the time limit, I want to be sensitive to your time frame.
Well,
and
thank you.
so if there's questions or you'd like more information on whatever.
Sure. No, thank you. I appreciate that. We do have at least a couple questions. Delegate Stewart?
Thank you, Madam Chair, and thank you, Mark, for joining us this morning. We really appreciate it. So I just have a quick question. Maryland seems to have a relatively unique system regarding gift exceptions, where in Maryland, in the sort of good old days / bad old days, lobbyists could just take a legislator out and pay for their meal just one-on-one. But that was amended several years back to create an exception where the only time that lobbyists can take legislators out to meals is if they invite an entire legislative unit. In other words, basically like an entire committee. And so we have a system in Maryland where a lobbyist firm, for example, can invite out an entire committee like this one here, and then pay. There's no restriction on the amount of money that the lobbyist could spend on food or beverages. And so my question was, how unique is this setup? I mean, my cursory research suggests it's pretty unique not to have any sort of dollar cap or to have this exception. And you may not be able to answer offhand. So, I mean, you feel free to, follow up with us or whatever, but that's my question. And I appreciate, again, your time.
Oh, sure. Yeah. Well, thank you, Delegate Stewart. That is actually a great question. Seriously, it is. And let me just give you a little bit of background. When we first in Wyoming first passed our first, Ethics and Disclosure Act, I think we put in there like 20, I don't know, it was like $5 or something. It was really, really limited. And by the way, states are all over the gamut on this. I happen to live in Denver, Colorado, which is a no cup of coffee rule, meaning you can't even buy a legislator or staff a cup of coffee. That's considered absolutely no. So there's no, when you go out, it's kind of interesting. Although, so in Wyoming, the first iteration of the law was, $5. Well, you'd think the argument would be over a cup of coffee. Do you know what it was over? A shot of whiskey. And so the legislators were like, oh my God, I can't even. I had one of my favorite people. She looked at me and she goes, let me tell you something, Mark. If any dumb's SOB thinks they can buy my vote for a steak and a shot of whiskey, they're wrong. It wasn't like steak and a glass of wine. It wasn't a cup of coffee, shot of whiskey. That's big in Wyoming. Anyway, so the pushback we got, it wasn't so much from the legislators, it was from the citizens. And their point was, oh my gosh, we have, like you guys, have these meetings all over the state. We invite people to come. Sometimes they stay in my home. Are you kidding? I can't even, again, share a shot of whiskey with them because of the $5 limit. So they just eliminated it. So now in Wyoming, food and beverage, there's no limit. So to answer your question, Delegate Stewart, I think that's an interesting threshold to say, come one, come all. And if you all come, then you can have, a meal with no limit. I agree with you. I think that is rather unique, very unique. But what I always say when I get called by the press, and the question I'll usually get is, give me an example of what you think is a perfect state law on this. And I'm like, yeah, no. NCSL, we have all 50 states members, including yours, and you're a very valued member and we appreciate it. I just say you really have to work with, because what's appropriate in one state might not be appropriate in the other. Like I said, Wyoming, bring it. Let's have whiskey and a steak. Colorado, nothing. So what's appropriate in Denver, Colorado might not be appropriate in Cheyenne, Wyoming, or New York City, or Annapolis. It really is up to the state. And that's the best answer I guess I can give, Delegate Stewart. I don't know if that's the best answer for you, but I would just say, if you find it unworkable or inappropriate, then we kind of leave it up to the states to say, okay,
Sure.
this isn't working, fix it.
Thank you. That's helpful. Delegate Terrasa.
Yeah, as you heard, and I appreciate all the information you've given us so far. As you heard, we've struggled a lot with social media and newsletters and social media. And so I'm wondering if you've seen a trend, if you guys have information on what that's looking like across the country. It seems like that might be something that's we could use some guidance with, and maybe others could as well.
Your question is terribly timely, and I did enjoy your question. I listened in on the last presentation. My colleague out of our DC office, we have two offices, Washington, DC and Denver, Colorado, and my colleague in the DC office is our Director of Communications. He and I just presented to the Illinois Senate Democratic Caucus 2 days ago on ethics and social media. Now, I know that doesn't sound like maybe they go together. We think they do. And so we just gave a large presentation. So the answer is I can get you in touch with him, and he has many resources. I mean, we can generally at NCSL, we can completely bowl you over with all our information. But yes, we have a lot. And the whole blocking people is very sensitive. And I'll tell you why. It's I'm a lawyer. And so I remember these issues coming up, even in Wyoming, where, shot of whiskeys give people a lot of opinions. And oh my God, they get on social media and just come out blasting. So I will tell you that the issues, and I was glad that your counsel, I think Dia, am I saying that right?
Mhm.
Was answering that, because that's who you defer it to, because in your state, it's always different. And I was very interested to hear her say there's an AG opinion in Maryland, which I should probably read on the First Amendment stuff, especially when it comes to personal. Now, when it comes to your public one, I've always just said you have to be careful blocking people. Even the president had to be very careful blocking people because it's paid for by taxpayers. So there's a different interest in something that taxpayers are paying for than maybe your own personal, Facebook page or something like that. But we do have resources on that, and I can put you in touch with a lot of that hopefully will give you some guidance on that, if that would be appropriate.
Thank you. That would be, yes, feel free to send on guidance, and we're happy to circulate it among our members.
Delegate Lehrman, can I just really briefly, in addition to that, I think some of it is also how we use our newsletters.
Yeah.
And how we can use our newsletters, our state newsletters, versus campaign and use of our campaign newsletters versus our state newsletters. I think blocking is sort of a small piece of what we struggle with. It's how and whether we can use our state newsletters, who we can contact, how we can contact them, and what kind of information we can send out is another thing we struggle with.
Yeah.
But thank you. I appreciate any information you have for us.
And our chairman has a comment that he'd like to make as well.
Yeah, just two things on this whole blocking thing. My policy is I block anything that is obscene, racist, or threatening. I have that on my 2 Facebook sites, and that's what I do. And I'll just double check with Dia as to whether or not that's a good policy. I've never blocked a person in their entirety. And whenever somebody uses an obscenity, I report them to Facebook. I don't do Twitter very much, so I don't know what's going on in that. I just wanted to give a little bit of context to the whole issue of taking out an entire committee or the entire legislature, because when it was proposed initially, it seemed like kind of like a dopey idea. And the way it was defended on the floor, I'm old enough to remember this. The way it was defended on the floor was to say that rather than allowing a lobbyist to take an individual legislator who voted the right way out to dinner at Lunasis or Ruth Chris, if you take out an entire committee or the entire legislature, in effect, you're buying a meal for the people who voted with you and against you. And that was the rationale that was used at the time the law was implemented. And so, I mean, that was the rationale that was given, and I'll leave it to the members of my committee as to whether or not they think that's a sensible rationale. Thank you, Brooke.
Sure, thank you for that history. That's helpful. Appreciate it. I had actually one question, and I'm not sure if it's for you or for Dia. Who should answer this, and maybe I should have asked it before, but I'm curious about retaliation. And I don't even know if Dia is still on, but whether, we in Maryland, or whether what happens in other states, if somebody retaliates against an individual for reporting or participating in a investigation of a potential ethics violation, if it's common for, how we protect people from retaliating against those individuals. And is this something that you've seen in other states, Mark? Is this Dia? I'm not sure if Dia's still on. I don't have my whole view on, but I'm just curious if this comes up. Okay, I'm curious if this is something that we regulate in Maryland, and if not, why not?
So I can talk about what we do on the legislative side. Jen may want to talk about what they do on the Ethics Commission side. For us, is there a specific provision other than harassment and discrimination, which has an anti-retaliation provision, but for the other provision, the other standards of legislative ethics, can I point to something that says, it's a violation of the ethics law to retaliate against someone? No. Historically, what we've done, we can say it is outside the standards of decorum expected of a legislator, and the Ethics Committee has certainly taken action for people who are not following our standards of decorum and civility. There is an argument that depending on what you're doing, maybe it's a prestige violation. If you say that you try to get me fired because I filed a complaint against you, and you're going to HR as Delegate Learman, maybe it's a prestige issue, but no, there's not a specific provision that says retaliation is illegal like we have in harassment and discrimination.
Got it. Thanks. Is this, Mark, is retaliation, protections against retaliation, other states have laws on the books about that?
Yeah, and when you say retaliation, can you tell me what kind of retaliation you're talking about?
Well, it could be anything from, firing to demotion or notes in somebody's employee file with demerits. I think there's retaliation can take many forms, not choosing them for a, special work assignment. I don't know. I'm a wage and hour attorney as well, so I could give you lots of ideas of what retaliation can look like, but just curious. I assume that states do have these sorts of laws on the books.
Yes, Madam Chair, that is true. And the reason I'm kind of befuddled is because I don't think we track that in the Ethics Center for laws on that. But I will certainly look that up and send you any link to information that we may have on that. Happy to do so. But yeah, that isn't something I guess that we keep track of.
Okay, thanks.
Sure.
Well, thank you so much for joining us today and for being such a great resource. Your website at NCSL is very helpful. There's a whole section dedicated to ethics laws, which I found really helpful last year in the middle of session, just looking things up. So thank you for all your work. We really appreciate it.
Thank you. Thank you. Nice to talk to you all.
Nice to talk to you. Take care out there out west.
Thanks. I will.
Yeah. And now we're going to hear from Professor John Willis, who's going to talk to us a little bit about his perspective as a former Secretary of State and as a law professor about his perspective on ethics laws, about 8 minutes, and then we'll have questions for Professor Willis and we'll wrap things up. Thanks so much for joining us, Professor Willis. Are you on? Are you muted?
He's here. Might just need to unmute.
John, if you're on. Oh, there you are.
Get rid of some background noise. Well, thank you very much, Brooke and committee for asking me to appear. And I want to not take up too much time, but I do want to give you some context. And that is, I spoke to your subcommittee chair and I thought, let me get rid of some noise. Can you hear noise?
Yes, we can hear that noise. It would be great to mute it.
In the old radio programs, they used to tell call-in people to turn off their radio.
That's funny.
Many calls at one time. What I thought I would do, first of all, from a historical perspective and from a perspective of good government, what you're doing is absolutely critical. As you know, many surveys, there's a decline in public trust in the institutions of government and in particular individuals who are serving in government. And that is a big concern for all of you and for the body politic at large. And it's important that your committee, the work you're doing, bolster the confidence that the public can have in its institution and in its public officials. Let me just abstract a little bit as you consider some specific proposals in the upcoming session and in your ongoing work. And what is it that impacts public trust and confidence? And one thing you need should bear in mind all the time is political culture. And political culture is not just the elected officials, but it's also the citizenry and the dynamics of what expectation the public has about the role of government and their relationship to government. And there's a typology that's used in political science, and there are others, but a classic one is by Professor Alazar out of Chicago, where you have three different cultures. A moralistic culture, which is not the same thing as religion. It's not religiosity. It's about the duty of a citizen to participate in government, that it's part of your obligation as a citizen to be involved, be engaged. And in those cultures, you tend to have high voter turnout, high service of strata of people in society in elective office and in boards and commissions. And in that culture, you tend to have less corruption and less problem if everybody sees it as a civic obligation and a duty. And then you have a traditionalistic culture, which is very hierarchical, rooted primarily in the South, where government leaders and government people, think of it as a pyramid, and government is viewed as only providing essential services, not really services that extend beyond bare services for a society. And there you tend to have lower participation. You have some corruption issues that are rooted longstanding. You can think of Louisiana as a prime example of that, and other areas where that culture thrives. Then you have individualistic cultures, which are, the view of government is what's in it for me? What is it how can I benefit? And it's not just the political leaders that may reflect that, but it's also the citizenry views government in that way. And Maryland is an individualistic culture. We've always been transactional. And in thinking about what I could help the committee with, that goes back to the very first sessions of the Maryland General Assembly in the 1780s, where even Samuel Chase, some of the old historical names that you know about, were involved in ethical controversies, passing legislation that favored either the creditors or the debtors, speculation over acquisition of former British property, land speculation, a whole bunch of rules. And you may think of Samuel Chase as a signer of the Declaration, or, instrumental in early. He was censured by the state Senate for his conduct in trying to get a bill through the legislature. So you've been dealing, as an institution, you've been dealing with this issue for a long period of time. So culture is really important, and it also may inform, if you think of, each one of you think about, how do I approach this issue? And if you think of it, well, where am I coming from? Now, all states, and in Maryland, we have a mixture of those cultures, but the dominant culture has always been an individualistic culture. The other is the structure. What kind of structures do you place? And your ethics, the executive director and the ethics commission director outlined the structure that was put in place here in Maryland in the 70s in reaction to a very dark chapter of Maryland politics and government in the late 60s and 1970s. I'm a little older than the chairman even, and I said to your subcommittee chairman, Brooke, I said, I know all these people. I mean, I can remember the people I personally dealt with in the official capacity and in political capacity with everybody back to the 60s. But the institutional structure is checks and balances, which the legislative primary function of the legislature, you do that. It's the laws you put in place, and it's your internal procedures. And in a historical perspective, you've done a good job on that in the last 50 years. And I think if you would compare us with all due reference to Wyoming or the Rocky Mountain states, but we're very different than many of them and many of the southern states. One example I use all the time in class on campaign finance is there are basically no rules in Virginia, and we have a structured environment here in Maryland with a few exceptions. So that institutional structure, which you're focused on here, is very important. And the creation of Dee's office of the counsel to the General Assembly was a big step forward. That doesn't mean you catch everything that happens, but that is an important function. And the third is, of course, the conduct of the public officials themselves, whether they're legislators, they're executive branch people, they're state employees, state and local government. You know, those people, how they do their job is going to impact the public's attitude in public trust. And so what are some key principles we see that are important? Transparency, accessibility, openness, ease of understanding. We're probably pretty good on most of those. Some of our documents and disclosures are not, I would say, that readily accessible, or is it easy to understand them? And I think the committee may want to focus on making that more accessible to the public and easier to understand, whether it's definitions or whatever. And as your previous presenter said, technology presents a new challenge. And many of the bases of the laws, it's amazing how much of the statutory language stays there decade after decade. I mean, there's 2/3 of the original Constitution Declaration of Rights in 1776. The language is still there 240 years, and some of it needs to be revised and updated. And the same thing's true about our ethics laws. We're out of date. We passed something, but then 10 or 20 years later, the technology changes. And as Mark pointed out, the Texas law doesn't say anything about electronic contact with a legislator. And so those kinds of definitional things you need to take a close look at, because we do lag in those areas. There is also, I think, a need for clarity for all the people, clarity on the part. Now, the Ethics Council, your Ethics Council for the General Assembly helps you provide that on an individual basis, but it would be good for the public to know, here's what a legislator can't do and not do. And let the public know, don't do that. Don't make that offer. Don't expect your legislator to do something. And there, I think some informational clarity, for the public to make them aware would be very helpful to work on the culture issue. We need to really transition away from, there's a lot of books written about the late 19th century and early 20th century, the Gorman-Raisin political boss machine, and how it patronage and what's in it for me was the dominant way of doing business. It's what got Governor Mandel in trouble with the quid pro quo of what benefits me and what benefits you and certain business interests. So there's a need for guidance for not just for you, but for the public, for the executive level positions, and for candidates. Our campaign finance is another area. It's not the specific subject of today's hearing, but there are a lot of things. The one that cropped up this year that I was astounded by was the Ballot Issue Committee, there are very little language in the election law article about what can they do and not do. One thing we know they can do is they can accept unlimited amounts of money. And in fact, the FanDuel and its competitor have contributed $4.25 million to their advertising campaign, unlimited amounts of money. But that Ballot Issue Committee has now sent out flyers supporting candidates. But we have a limit on how much money anybody can give a candidate. And so there's just a total absence of what can a Ballot Issue Committee do and not do, and it seems a little silly to have a limit on the state contributions to candidate, but go in the back door through a ballot issue committee and get all your campaign materials printed by the ballot issue committee. It's a gaping hole that needs to be filled. Same thing with 529 organizations and so-called dark money and super PACs. There's a lot of work to be done in those areas. And with regard to public officials and the Ethics Commission, I fully support they're getting more resources because they're dealing with a pretty high volume of activity. But there is a need also in the area of income, being able to disclose outside income, particularly of maybe you pick a limit of, people at a cabinet level and constitutional officers and public office holders or something, but there needs to be more clarity and disclosure about what are the sources of income, what are the properties involved, the fiction, breaking through the fiction of an LLC and not having disclosed who the members are who are in business with a public official. Those are areas that I think deserve further exploration.
Thank you.
Subcommittee chair, here's what I promised you that I would here are the resources that I would do. One, for a lot of the early stuff is Brugger's book on, my virtual screen doesn't do it, but Robert Brugger, professor at Hopkins, wrote some very good passages about the various periods that surprisingly what you're facing, happened in the 1890s. Brugger's book, Professor Calcutt, history professor, now retired at University of Maryland, wrote a more contemporary book called Maryland and America, 1940 to 1980. And on one page, this is astounding, this page, I'm going to send it to you. He lists on a whole page the fact that we had 2 governors, a senator, 2 congressmen, 4 state senators, 4 House of Delegates, a Speaker of the House, county execs from 3 different jurisdictions, sheriffs, court clerks. It was a virtual litany of public corruption cases.
Right.
Prompted. I'll send you that. And of course, chapter 5 in my book is in.
Okay. Yeah, no, that would be great. If you want to just email those to me or Trish, we'll make sure that that it's distributed to everybody. So thank you.
Sorry for going beyond time, but that's.
No, you're good. Thank you. You're a professor, so you have it all in your head, and we appreciate you sharing it with us. I don't see any questions, so I think we'll leave it there. But that was really a great way to wrap up, I think, with some Maryland history and historical perspective about and some of the holes that you see in our laws. So thank you. Chairman Barve, do you want to make any final comments?
Well, good job, Brooke, and good job to the members of my committee. It's great to see all of you. John, great to see you again as well. And this has been an informative briefing. I've reached out to the other subcommittee chairs to ask if they want to do any briefings. And so we're going to try and do 1 or 2 more of these. And in the meantime, if you have any reason to reach out to me, please do so at kumarbarve@gmail.com. And also, I want to emphasize that if the presenters want to send us information, they should send it either to Brooke or to Trish Gagnon, who's the chief of staff for the committee. And that way, the information can be disseminated to all the members of the committee simultaneously. And so, Delegate Learman, thank you very much. Members of the committee, presenters, thank you, and have a great